Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. So today's topic is going to be a question that I get a lot for every probate consultation. And I was thinking, I hear this question multiple times a day, countless times a week, from clients and from family members and friends. So I thought, why don't I bring it to you? It's how to handle an estate in New Jersey. So, before we dive into this topic, if you have any questions pertaining to estate planning and probate and you want to schedule a free, yes I said free, strategy session over the phone with me, you can contact me at njestateattorney.com. Go over there, set up a day and time that works best for you. So let's dive into this. So how to handle an estate in New Jersey. So New Jersey, as we've said previously in previous videos, we are one of the cheaper states to conduct probate, and it's going to be under about $200. But here's the process. After somebody passes away, you have a 10-day waiting period. And what that period does is it allows you really, how I always interpret it is, it gives you that morning you can grieve, but you don't have to do it on day 11. You can open up the probate when you are ready after that 10-day period. Now, what you're going to do is you're going to open up the probate in the county where the person passed away. And you're going to provide them with your forms, which you can most likely find online. If not, call your surrogate's office, and they will provide the forms to you. You're going to give them a copy of, if there is a will, the will and a original death. You're going to give them the original will and an original death certificate. And they're going to open up probate. You're going to get your letters of testamentary. Now what you have to do, this is where being the executor or the administrator becomes a little bit more challenging. What you're going to do is it's your task to collect all the financial assets, all the personal assets, vehicles, and really get all of those assets, bring them together, and open an estate of bank account with those assets. Or you're going to need to, you may have to, on vehicles, on personal belongings like antiques or collectibles, get them appraised for value. And it's your job to safeguard these assets for the time being. As you go through the mail, you're going to see that before we dive into that, but there is a 9-month creditor window, and that window begins the day the person passes away. So you have to wait 9 months for all the creditors to come out of the woodwork. And how you're placed on notice is receiving a bill directly from that creditor, if it's addressed to the person or the estate of. That's how you know that they're creditors. And it's your job really to collect all these creditors. And you can check on if they're valid claims or not. And if you're not sure if there was any other claims that may be out there, you're tasked with the job to go out and find if there were other creditors, usually by posting something in the newspaper. Then what you do after that 9-month period is you collect all the creditors, you collect all your assets, and you go, how can I pay out people? How can I pay out the creditors? How can I pay out the professionals I hired? How do I pay out the executor? And how do I pay out the beneficiaries by the guidelines of the will? And what you're going to do is then you're going to pay out the creditors. You're going to pay out, if you have a solvent estate, you're going to pay out your creditors. You're going to pay out your professionals, the executor, and then the beneficiaries, but whatever's left over from the estate. If it's an insolvent estate, it becomes a little bit more tricky. We have a statute that we need to follow. We also have some court, not proceedings, but paperwork that needs to get filed for approval to get a court order prior to making those payments. But we've jumped into that in previous videos, and we'll jump into it again. And really you pay out your people, you pay out the beneficiaries, and at the end, you close out the estate of bank account, and you can send in paperwork to the surrogate. It's just one last form that's basically like a revocation of bond or a reimbursement of bond form. Pretty simple. I hope this video helps. If it did, please hit the like button. If you know somebody who may be an executor of an estate, has questions about probate, share this video with them. Tell them you were thinking about them. If you have any questions pertaining to this topic or any other topic in estate planning and probate, and you want to schedule a free strategy session over the phone with me, head over to njestateattorney.com right now and schedule a day and time that works best for you to talk. I love talking to people. As always, my name is David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Have a great day.